of Drew Davis, Ricky Pirtle, and Marshall Young, and we will present stages of a criminal case before trial. Initial investigation options include a grand jury or a judge. Option one, the grand jury. The Fifth Amendment to the United States Constitution requires a grand jury indictment of criminal cases in federal courts. A subpoena would have to be issued for the suspect for alleged criminal offense. Um, the suspect is not allowed to have a lawyer in the courtroom. However, he can confer with the lawyer outside of the courtroom. A secret hearing for the determination of sufficient evidence to indict the suspect is conducted by the grand jury. Either the grand jury must indict the suspect on the criminal offense, that is, the grand jury will have to issue an indictment and continue the proceedings, or the grand jury must dismiss the proceedings for the criminal offense. In the second option, a judge issues the subpoena for the suspect, and the judge conducts a preliminary hearing to determine whether there is sufficient evidence against a person charged with a crime. Either the judge must indict the suspect on the criminal offense, that is, the judge will either issue an indictment and continue the proceedings, or the judge must dismiss the proceedings for the criminal offense. And next you will hear from Ricky for the rest of the stages.
Okay, the next category here is arrest. An arrest occurs when police take custody of a person upon suspicion of having committed a crime. At that time, they will inform them of their basic rights. The United States Supreme Court held that to protect the privilege against self-incrimination due to the Fifth Amendment. Basically, when they tell them the rights, they tell them after the arrest and before questioning, they have the right to remain silent, and that anything that can be said can be used against them in the court of law. Within 48 hours of the arrest, they will meet before a judge, and that meeting is called the arraignment, where they will be informed of the charges, and they will determine whether the person can be charged. There will also be a bail set by the judge, and the amount of money that must be given to the court to get released before the trial. The reason for the bail is to make people show up for court, and for people not to go to jail before court. Basically, that means that they can pay money to get out of court before the trial, so they won't have to spend that time in jail. The Eighth Amendment also prohibits excessive bail, and they determine that based on a few different things for the amount. First one being nature of offense, is determining how harsh the crime is. It also depends on the defendant's prior criminal record. And also it's the court's assessment of how big of a flight risk the defendant is and their threat to their community. So that will take us into the plea and the rest of it, and I'm going to hand this over to Drew.
Alright, the plea. It happens at the arraignment or the subsequent hearing. The defendant is asked for initial plea of guilty or not guilty. If this plea is not guilty, they go to trial, and if the plea is guilty, they'll go to a sentence hearing. At the plea guilty, it's where, in most criminal cases, the trials are avoided. The prosecutor offers the defendant a compromise, whether the defendant pleads guilty in exchange for a reduction of the charges or a lessened sentence. The plea bargaining can occur any time before the trial begins, and occasionally during the trial itself. It goes into the discovery. At both the federal and state levels, the prosecutor must disclose to the defendant any evidence that would help the defendant to establish his or her innocence. For instance, these could be eyewitnesses, alibi, or criminal investigation results. And that concludes the stages of criminal cases before trial. Thank you.